This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. The wrongful death suit filed by the Baez family against the New York City Police Department is among a growing number of cases being retried in civil courts by the families looking to receive justice they felt they were denied in the criminal court verdicts. Today we'll talk to the Honorable Edward Rappaport, Justice of the Supreme Court, Kings County, and see how civil cases differ from the criminal trials. We'll also talk to Susan Carton, the attorney for the Baez family, about the lawsuit she has filed against New York City arising at a case in the Bronx. Hello, Judge Rappaport. Hello, Susan.
Hello, Alan. How are you?
Susan, why don't you start off and tell us what is the status of the Baez case, what happened there, and where is it going now?
Well, as we all know, there was an acquittal of Officer Lavoti in the criminal trial, and we had last year filed a civil suit in the same county, same courthouse, that is now going to go forward. We had a conference with Justice McKeon on October 22nd, and the judge has now asked all parties to put in a motion. And the main issue now before the court is the position that the City of New York has taken is that Officer Lavoti was not acting as a New York City police officer that night and was not acting in the course of his employment. As crazy as that may seem, Alan, but that's the position of the New York City Corporation Counsel's office, even though the entire criminal case was tried on a theory that Officer Lavoti was acting as a police officer. He was in a patrol car and he was effecting a lawful arrest. So Justice McKeon has asked that motions be filed on this issue. Officer Lavoti's counsel has taken the position that Officer Lavoti was acting in the course of his employment, and so do we.
Let's see if I understand this. Are you saying that it's the position of the City of New York that at one point Officer Lavoti was acting within his authority, I assume when he got out of his patrol car and did whatever he had to do, and then at some point his acts were beyond what they expect a New York City police officer to do, and he was acting on his own?
That's what they seem to be saying. They seem to be saying that in terms of indemnification, in other words, whether the city would indemnify Officer Lavoti for his acts that night.
Wait, let's talk terms of, by indemnify you mean pay money?
Pay money, exactly. They want to be cut loose here. They don't want to have any financial responsibility to the Baez family.
I don't want to discuss the Baez case with you because that's a pending action.
Case, right.
However, the theory in general, in civil cases, how does it work that, let's assume an employer, and here this was an employer.
He was an employee, you mean?
The employer with the
City
of New York.
Employer.
At what point does an employee's actions not make the employer responsible?
We're talking about acting within the scope of his employment. For example, if a bus driver is driving his bus and he negligently hits someone with his bus as he's operating it, one could say that's clearly within the scope.
Sounds like it.
If the bus driver is driving his bus, stops the bus at the curb, gets out of the bus, walks over to someone 50 feet away from the bus, and smacks that man in the mouth with his fist, causing him to lose 3 teeth, one could make the argument that that is not within the scope of his employment. He wasn't hired to be a combatant in the street, he was hired to be a bus driver. Scope of employment, which is what we charge in cases where you try to hold someone, not the person who is the actor, but who employed the actor responsible, is many times a question of fact. And it's something that has to be decided by a jury as to whether or not the person who acted was doing it with, in furtherance of his employment. Now, in the case, any case, it doesn't have to be the Baez case, take other cases which may or may not have even had a criminal prosecution, but an incident takes place, and a police officer, let's say, is involved in that incident. Usually the police officer, where the city does not want to represent, you have to understand the city's principal client who the corporation counsel represents is the city.
Right.
And if they perceive a conflict of interest between an instance of a police officer and the city of New York, they of course have to represent their primary client. And they tell, therefore, the police officer he has to get his own attorney, which obviously, from what Ms. Carton has told us, happened in this case. He has his own attorney, we call Police Officer Livoti. Now, obviously, the police officer, who may take the position that he did nothing wrong, still wants to be deemed to be acting in the scope of employment, because if the case goes bad against him, he wants the city to pay the judgment.
He doesn't want to be personally
He doesn't
liable.
want to be
They don't want to have his
personally
house
liable.
taken away, or...
He would be personally liable. He would be personally liable if a judgment is gotten against him, but if it's in the scope of his employment, the city then indemnifies him. You didn't like that word before.
Well, because I want to explain it to the
Right.
public. The
Okay.
city would pay any judgment.
Exactly. Now, also, a plaintiff in this type of lawsuit wants them to be in the scope of employment, because if they get a sizable judgment, they want to be able to collect it. The city's deep pockets, so they would like the city to be held in. But forget the city and a police officer. Let's say someone works for AT&T, and it's an employee of AT&T, and that employee does something which becomes a subject matter of a tort action, be it battery, false imprisonment, whatever it may be. The person suing the employee, who may be a man making $35,000 a year with family, modest means, would like to hold in AT&T, deep pockets again. So you always try to, in these lawsuits, argue that the person who did the tort is a civil wrong, acted within the scope of his employment.
Now, Susan, I assume that's part of your concern, that if the city is not responsible, you could not collect your judgment.
Well, of course, it's part of our concern, and I think it's a very, it's a specious argument. In fact, at the time that it was proffered by the city or brought up to the judge's attention, he indicated that he didn't think the city has the right to make that determination. That's something that a jury should make in terms of whether Officer Livoti was acting in the scope of his employment. But, Alan, we also have another theory in our case that I believe would hold the city in no matter what, which is one of negligent retention. Our argument is not only that Officer Livoti's acts that night in choking Anthony Baez to death were negligent, but that, and he used excessive force in the course of his employment, but also the city of New York was negligent for retaining him as an employee and keeping him on the force, even though he had 14 civilian review board complaints against him, and even though he was in a special, what we call, force monitoring program. This is a special program set up by the New York City Police Department for officers who have a certain amount of excessive force complaints. And so the city of New York was on notice of this officer's conduct for a good period of time before the Anthony Baez death, and it's so our argument that he should have been cut loose way before this.
Judge, are there any cases that you know where the city has been held liable for keeping a police officer on the force longer than they should have?
I don't know about the city necessarily, but there's a lot of, the city is only an employer, just like any other employer. There are many cases where either you could hold an employer for negligent hiring, that they shouldn't have hired this person and put him into that position in the first place. And I think there are cases involving, if not New York City police, or police officers throughout the country, that you have to be very careful in the way you screen and hire a police officer who you're going to give a gun to, and to go out and to do police work.
Screen and hire, but continuously.
Then if you have that concept, that you have to be careful in who you hire, once you hire someone, you have to have some type of screening process to make certain that the person you hired is fit to perform the job for which you hired him. Now, how these cases turn, that if facts develop that shows that the officer has a problem, and then they do not do anything about that and permit him still to perform his duty, and if it's because of that problem he commits an act, that could be a vibrant lawsuit. For example, let's assume, which has nothing to do with Ms. Carton's case, let's just take hypothetically that a police officer becomes an alcoholic. He becomes a drunk. Now, if the police department is aware of it, assuming that they put him into some type of program, still let him keep his gun, still let him go out in the street, and didn't screen him to see if he was drinking or not, and he got intoxicated at a particular time, ends up shooting somebody. Isn't that something that could be a negligent retention of someone where they have knowledge that he has a drinking problem, and as a result of that drinking problem...
See, and in this
cause harm
case,
to
we
someone?
had four of the 14 excessive force complaints were for choking, were for excessive force in the same modus operandi.
So he had done it before.
He had done it before. In fact, he is going to stand trial on January 8th for another case, a misdemeanor, where he choked another individual in the Bronx. But in that case, thank God, the young man did not die. He was sent to the hospital with hemorrhaging on both sides of his
Judge,
neck.
let me ask you
Yeah.
this. I know before becoming a judge, you were private defense counsel. In fact, you even represented, in some cases, the Police Benevolent Association. What I want to know is if the city is allowed to say that once a police officer does something that they don't like, that they're not responsible. Isn't that like a carte blanche for the police officers?
No. First of all, the fact that they say that he did not act in the scope of his employment is not in any way a resolution of that fact. A jury's going to resolve that fact. Generally, for example, what usually happens is, what they do is they refuse to represent. That they have a right to do. They don't have an obligation to give legal counsel to the police officer. However, what the police officer does in his lawsuit, one of the things he asked for against the city, is that he wants them to pay not only any judgment that's gotten against him, because he contends he's acting in the scope of his employment, but all counsel fees, because it would be a person like that's position that he shouldn't have had to go out to hire an attorney in the first place. They should have represented him. Now, I have represented in civil matters police officers when I practiced law where the city declined representation because they said there was a conflict of interest between their major client, the City of New York, and the individual police officer or police officers, where the police officers had to get outside counsel. And the city, in some instances where they were wrong about that, and it was in the scope of the employment, not only did they pay the judgment under the concepts of indemnification, they also paid for the attorney fees.
That'll be your fee.
To cover my fee. Now, that doesn't always happen.
So what's happening? It seems that you cannot turn on a TV now that there isn't some lawsuit either suing a defendant like O.J. Simpson or Bernard Goetz, who got a $40 million verdict in the Bronx, which I understand is not collectible.
Well,
Yeah, but the reason that people are bringing these suits, and the reason that the Baez family has the only option right now is the civil suit, even though the U.S. Attorney's Office is looking into this in terms of civil rights violations. We have had several meetings with Mary Jo White, and there is a federal investigation going on now to see if there can be civil rights violations charged against Officer Lavoti and the other 4 officers that were there, because there are conspiracy statutes. So this is similar to like the Rodney King situation. But I think what's happening in our country is that more and more we're seeing that people are not getting justice in the criminal courts, and it's falling more and more on the civil lawyers to be the ones to get some measure of justice for these families. Now, the Baez family isn't going to...
when you say I think we're mixing a lot of things up. It has nothing to do with justice in the criminal courts.
No, we're seeing the juries who are not
it may be
convicting.
that
We're
juries
seeing
are not-
judges letting people go. So, I mean, there's a
But
perception out there.
I don't know if that's a denial of justice or a different quantum of proof. Now, as you know, Alan, and I'm sure you also know, that in a criminal case, the quantum of proof is reasonable doubt. In a civil case, it's the preponderance of evidence, a fair preponderance of evidence, at least in the cases that we're talking about. Now, that's quite a different type of proof. Now, also, police officers have this problem where a police officer is charged with a crime, is found not guilty, and then he's brought up on disciplinary charges by his department and fired. And, of course, the police officer feels in his own mind that's unjust and unfair. He was found not guilty. But the proofs are different. In a civil service proceeding, which is what a disciplinary proceeding is, that is substantial evidence, is the proof, not reasonable doubt. And many police officers find that they end up being fired for an act that they were acquitted of in the criminal court.
Susan?
Yeah, but that's not what we're talking. We're talking about situations where we're going into the criminal court and police officers are waiving juries. They won't go before a jury of their peers. They ask for judges to decide cases, where juries have an agenda where they acquit people where there's overwhelming evidence. And so therefore, we're seeing more and more of the burden falling on the civil court to be the ones to get some measure of justice for these families.
Are you saying that you feel the judge is bending over backwards to the police?
Well, I don't know why it is that no other defendant in our society waives a jury except a police officer.
Well, that's not true at all. When I tried as a defense attorney, non-police officers, just regular people, I waived many a jury.
What about when you represented the police officers?
I tried most of them before juries. I tried the Tosny case before a jury. I can go on and on.
Well, why did Officer Lavoti not take a
I
jury?
can't speak for, I don't know.
Why is he not taking a jury in the next trial?
I don't know Mr. Lavoti. I don't know any of these people. First of all, he doesn't have a choice in the civil case. All you have to do is make a jury demand.
We're not going to, he's going to have a jury
All right,
there.
but the point is that for almost every crime that you can enumerate that's in the penal law, there's a civil tort. If you talk about larceny, stealing, you have a civil tort that we call conversion. If you talk about an assault or an attempted murder, we have a civil tort that we call battery, and so forth. And there's nothing wrong, and that's the right of people to address a civil wrong, and the criminal is different. In fact, the parties are different.
Susan, do you feel that there's a breakdown in the system? Is that what you're trying to say?
What I'm saying is that I think that there should be jury trials, and I think that police officers should face the people that they pay to protect.
You're saying the defendant should not be given...
No, I think it should be like the federal system, where the prosecutor has to consent to the waiver of a jury. And I think that if you would have had this in this case, and this is a case that cries out for it, because we probably wouldn't be here discussing this case, and there wouldn't have been all the community outrage had there been a jury verdict here. And so I think that's the first thing that has to change, is that somebody just can't get up and wave their hand and say no jury, and this goes to a judge. Now, I understand Judge Rappaport is in the system, and he's probably tried cases in both sides, but the point of the matter is the perception out there. And I suggest that there is a terrible perception out there that there's a confidence, the confidence level in the system is being eroded.
Well, first of all, let me say that talking about civil wrongs and criminal crimes, the criminal crime in the Diaz case was criminal negligent homicide, which has a very specific and definitive definition. The action that we're talking about here, the civil action, deals with battery, deals with a violation of civil rights under 1983 of the federal law, and also deals with this wrongful retention, negligent retention. They're completely different concepts entirely. And it's like discussing oranges and apples. You really can't discuss that. The reason you don't see this type of lawsuit as often is that you either have to have someone where you could look to the city of New York where you're dealing with a scope of employment, or you have an O.J. Simpson who...
Deep pockets, is that what we're talking about?
I mean, it doesn't really pay.
Has money.
The only one that ever did this, and I don't know what the purpose was, when Getz was sued, and the lawyer that brought the lawsuit, who's a good lawyer, knew that even if he was successful, and he wasn't going to collect the judgment. He was trying to make some type of statement. Most lawyers do not take on that type of action to make some type of statement.
Yeah, but this wasn't taken initially.
I'm not talking about your action.
We have a widow who lost her husband.
No, you're missing a point. I'm not talking about you. In the Getz case, when they sued Getz...
They didn't care about money.
They didn't care. I mean, it was just... and there's a lot of money goes into these trials. I mean, as you know, you're a trial lawyer yourself. You don't try cases without expenses.
But Judge, what I want to know
if you do it properly in any event.
But it seems, as I said before, now it's in Fort Lauderdale, actually St. Petersburg, Florida.
Right.
There's riots, or there were riots.
It has nothing to do with civil action.
But what I want to know is, it appears that across the country that this is coming more to the forefront, with police officers either being acquitted or not being indicted. I mean...
well, do you think that every time a police officer is not indicted that someone did something wrong?
I have no idea.
A grand jury are made up of people.
No, but what we're saying is that most of
wasn't
these cases where a grand jury does speak and say that an officer should be charged, that officer is acquitted. And the perception around this country is that
You're not
officers have a license
suggesting, are you,
to
that
kill.
anytime someone's indicted, they should be found guilty?
I'm not suggesting that at all. I'm
All
saying
right, so
when
there
we're
was
seeing
a
cases
trial.
with overwhelming evidence, Anthony Baez's case was one with overwhelming evidence from the medical examiner that he was choked to death. And what kind of message does this send to the community when a judge lets an officer like this go and then says behind it that that the prosecutor didn't prove their case beyond a reasonable
Well,
doubt?
first of all, in the criminal case, all I know about the case was in the newspapers, but I do know that the judge that handled that case is a well-thought-of judge by everybody in our profession. He is a judge that is intelligent and learned. He has an excellent reputation. He's not in any way a judge that would compromise his own position as a judge. He was the one that sat and listened to everything. There was evidence put in on both sides. I don't think there was evidence put in as to the cause of death, as I read in the newspaper. I wasn't there. I didn't hear a word of it.
There was evidence put in.
And he made a decision based upon reasonable doubt, and he found this person not guilty. Now, if we're going to live in a society, whether it be a jury that finds someone not guilty or a judge finds someone not guilty, and we're going to have either the public lodge or public officials criticize the juries and the judges for what they do, assuming that they do it honestly, then we don't have a democracy anymore.
Do you feel we should adopt the federal system where the prosecution also has to agree to waive the jury?
No, because the right of jury is a right given to a defendant, not to the prosecutor. And I truly believe that a defendant should choose his form in which he's being prosecuted. Just like it would not be proper in a civil action to have, not to give a jury trial unless both sides wanted a jury trial. Let's assume in this action that you're bringing here that you couldn't have a jury trial. We could pass a law like that. You can't have a jury trial unless both sides agree to a jury trial. That would be as ludicrous as denying a defendant. See, it's the defendant that has to defend himself.
Judge Rappaport, thank you very much for coming down to Lawline. We're going to take a break now. Right after the break, we're going to hear from someone from the Baez family. Stay tuned. You're watching Lawline. Hello, I'm Alan Schnorman. Most of you know me as the host of Lawline, where I interview the most knowledgeable attorneys in the field of law today. So I understand the importance of choosing the right attorney to represent you. With so many law firms to choose from in personal injury law, how do you know who to call? At my firm, Zalman & Schnorman, we fight for the rights of accident victims. If you have been hurt in an accident of any kind, including construction accidents, you may be entitled to a substantial money award for your pain and suffering. Don't try to evaluate your case yourself. Call us at 1-800-LAWLINE for a free consultation. If you are too injured to come to our office, we will come to you. We get paid only when your case is settled or won. If you have any questions about your accident, call us at 1-800-LAWLINE. Remember, the insurance companies have lawyers representing them, and so should you. Hello, you're watching Lawline. We're here with Mrs. Baez, Anthony Baez's mother, as well as her attorney, Susan Carton. Mrs. Baez, what's the feeling of the community in the Bronx now regarding the Lavoti acquittal?
The acquittal, well, they're very upset because they feel cheated. The judge let them on, and he gave all the indication that this officer was guilty. He gave all the indication, like he let out all these right signals to pull the rug under them.
Well, do you feel there's a misapplication of justice? I mean,
Well, I think what she's talking about is the comment of the judge Friday before the verdict when he said that he believed there was a nest of perjury in his courtroom. And everybody after the judge had said that had thought that this indicated that there might be a guilty verdict of Officer Lavoti, although we were all mindful how difficult it is to convict a police officer. This was a very, very stunning remark to all of us when he made this comment to Officer Lavoti's lawyer, that he believed there was a nest of perjury in his courtroom. And then on Monday he went on to believe the same police officers that he referred to in his nest of perjury. So that's why the community feels so cheated here, and why it sticks in everybody's throat about what he did.
Now, what do you hope to gain from the civil lawsuit?
From the civil lawsuit? Really, just that, let the public know that this man was guilty. And just because the judge let him go, that doesn't mean he was going to get scot-free, because now it's going to the federal level.
Accountability. I think that's what the Baez family is looking for in our suit, is accountability, that a jury has to say that he committed this act. A jury has to say that the city of New York is responsible for his actions. And I'm sure if I came to the Baez family with an inordinate amount of money tomorrow and said the city offered this money to you for settling this case, or to Maribel for her life, that's Anthony's wife, who has been so disrupted as a result of this suit and this action, I don't think they take it. Because they want a jury to say, he did this. They want accountability. They want somebody to say liable. And that's what we intend to get when we get in the courtroom.
Now, I understand what you said before was, now there's a possibility of a federal criminal charges being brought against the officer?
Yes. After the verdict, we were contacted by the feds, and they are doing a very thorough investigation. Mrs. Baez went to meet Mary Jo White's assistants, U.S. attorneys, and they spoke to her, and they told her all they're doing. And we're praying that that will take its course, because that's the only forum where there can be punishment for Officer Lavoti. My forum is only one where we can motivate a jury to say accountability, and then make the city financially responsible to this family for what they've been through.
And if the city is not financially responsible, can you make Officer Lavoti personally responsible financially?
Absolutely. And the officer, I understand his pension vests this year, so that there is something here, even though I would not want to have to go that route. But I can tell you that we'll pursue Officer Lavoti no matter where he is and whatever he's doing throughout his lifetime.
Ms. Baez, what would you like to say to the public?
Well, and justice is there for the public. We just got to go and seek it, you know. There is good, like I said, there is good officers, but you have your racist officers and your corrupt officers. There is good judges, and then you got judges that are pulled by the string that will go either way. These are the judges we have to watch out for.
And if you had to speak directly to the New York legislature to change the laws, how would you explain? What would you say to them?
Let the jury decide. Let the peers, the people that are paying these officers to protect us, they're trying to turn it around now. We're paying their salary, yet they're telling us what to do.
Were you satisfied with the job the District Attorney Robert Johnson did at office?
No, from the beginning, it looked like something was wrong in there, from the beginning, because he was charged with murder. Then, after the technicality, I mean, when you have a open and shut case, like my case was open and shut. When you have an open and shut case, all you have to do is look at the evidence. I mean, you're not going to put somebody that don't know how to spell to do your paperwork, are you?
She's referring to the indictment being dismissed initially, which was the first blunder in this case.
That knows.
Susan, quickly, what would you like to say to the public in summation?
In summation, I hope that we restore confidence to the system. We have been slapped. The Baez family was slapped in the face by Justice Scheinlin. I hope that we can slap it back and make sure that
Mrs. Baez, thank you very much for appearing on Lawline. Susan Carton, thank you again
Alan.
for appearing on Lawline. As always, this is Alan Schnorman. Thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.